Okay, welcome everybody to the first research seminar of this term. I think we perhaps should close that door if someone can do that. Yeah. It's very good to see a lot of people back and have our first speaker here, Kirsty Gover. I'm going to speak about Aboriginality and Alienage, legal pluralism at the Australian border. And Kirsty is a professor at Melbourne Law School, where she's been since 2009. And she received her JSD from New York University with a dissertation on tribal constitutionalism, which I think this somewhat connects to. And you've written a lot about domestic and national law affecting Indigenous people in Canada, New Zealand, Australia, and the United States. Not yet about Sweden in this respect, but maybe that's coming up. And your research addressed law, policy, and political theory of Indigenous rights and jurisdiction. And you wrote and published with Oxford University Press the book Tribal Constitutionalism, States, Tribes, and the Governance of Membership. And you're working on a book entitled When Tribalism Meets Liberalism, Political Theory and National Law. And all of this connects to a new project we have here, the Territories of Democracy, run by Ludwig Beckman and Ulf Mörkerstam. So we are probably going to have a lot of things in this connection to this. It actually connects to a more general problem called the boundary problem in democratic theory, I think, so which I myself have worked on, so I'm very interested in this. The floor is yours.
First, I'd like to thank the Institute for organising the event and for the invitation to speak here today. And before I begin my presentation, I'd like to acknowledge the Sami peoples of Sweden as the traditional custodians of the land, and I would like to acknowledge the authority of their law. And I also want to pay a special welcome to any Indigenous peoples joining us here today. These types of acknowledgements have become conventional or customary in Australia before one begins a formal event, especially one engaging the interests of Indigenous peoples. And it's also important for people working in my field, which is, broadly speaking, the impact of settler law on Indigenous peoples, to position themselves by speaking to their identity in order to be clear about where one stands relative to place and people. And this is a way, I think, of putting oneself into relationship with First Peoples and First Nations, and also a way of putting oneself into relationship with country, which is a concept that I'm going to return to. And I'll just say at the outset, I mean country with a capital C as a political and legal idea that underpins Indigenous law. So for myself, I am a first-generation New Zealander. I was born and raised on the lands of the Kadimamoi Ngāi people of Aotearoa, New Zealand's South Island. I now live on Wurundjeri land in Naarm or Melbourne in Australia. And my research is comparative in nature, so I look at the four so-called Kansas states. That's Canada, Australia, Aotearoa, New Zealand, and the US. And because I'm interested in the intersection of Indigenous legal systems with settler legal systems, my research is positioned broadly within a field of inquiry that we would call legal pluralism. Now, as Gustav just mentioned, Ludwig Beckman, Ulf Mörkerstam and I are working together on a research project happily hosted here by the Institute called The Territory of Democracy, How Extraterritorial Migration Control and the Territorial Claims of Indigenous People Challenge and Reshape the Democratic People. And so today's talk will address an aspect of the second clause in our lengthy title, considering how Indigenous relationships to territory shape the national demos, by reference to the emergence of a new category of rights and interests claimed by non-citizen Indigenous peoples. And these are, more or less, claims to remain in or to enter the territorial space of a state of which one is not a citizen, by reference to your connection to traditional territory within the borders of that state. And I'm going to say that there are developments in the law of Canada and Australia which speak to the legal consequences in settler law of the enduring connection that Indigenous peoples have to their land, and the constitutional import of the fact that this connection has survived intergenerationally, notwithstanding the superimposition of the state form and the state borders over the territories of Indigenous peoples. So one way of thinking about this, which I have written about in other contexts, is to contemplate the fact that Indigenous polities underlie the international order of states. They're much older and more stable than that order, and increasingly they are not contained by that order's boundaries. And so work on the meaning and prospects of such a revised idea of territory and polity, informed by Indigenous legal and political theories, insofar as I have access to those, that will be my contribution to the project that we have underway here with the three of us. And so today I'll focus on just one important but very specific element in this broad set of ideas, which concerns the status of Aboriginal non-citizens in Australia settler constitutional law. And I want to invite you to think through with me about the meaning and transformative potential of some recent developments in the Australian High Court. And in a moment, I hope to provide a little bit of backdrop on the relevant demographic and legal characteristics of the Kansas states, and say something about the aspirations of legal pluralism as a field and its practical expression or lack thereof really in Australia and other states, in order to provide context for the ideas that follow, an acknowledgement that we're all from different parts of the world and that we all have different disciplinary focuses in our research. But first I wanted to say something about the crux of today's talk so that you have a sense of where we're headed, and that is what to make of a recent decision of the Australian High Court handed down in 2020 called Love-Thoms and the Commonwealth. And in this case, the High Court found that it is unconstitutional to treat Aboriginal Australians as aliens, even if they are not citizens of Australia. So in legal terms, there's now a new category of members of the Australian body politic who are Aboriginal non-citizen, non-aliens, an entirely novel status. In practical terms, this means that Aboriginal Australians cannot be deported from Australia. And I might say a bit more later on about the reasons why the Australian Commonwealth Government is so insistent on deporting some Aboriginal Australians. But for now, I think it suffices to note that since the decision was handed down, less than 20 Aboriginal men have been released from immigration detention and have avoided being deported back to their countries of citizenship. And that may indicate to you, as I think, that the importance of the case is more about principle and theory than it is about its real world impact. But I also don't want to diminish the meaning of this case for the families of the men who have been released from detention. So the question that lies at the heart of this decision, and therefore to my mind at the heart of Australian legal pluralism, is who is an Aboriginal Australian? And more precisely, is this question of status to be decided by Aboriginal peoples in accordance with their law, or is it a question to be decided by the state in accordance with settler law? And it's this very precise question of status and membership that is at the bottom of what I imagine is being something like a huge, very unwieldy, very complicated, teetering relationship of laws. Everything funnels down to this one precise point about membership of the polity and of Aboriginal communities. And so the implications of the case are huge, so much so that earlier this year, our previous government, a right-wing coalition government, sought to have the case overturned in an appeal involving the fate of a man called Shane Montgomery. This appeal was withdrawn just a matter of several months ago by our incoming centre-left government, but the question of status and Mr. Montgomery's status in particular remains live as these matters sort of percolate through the lower courts. As courts apply the High Court's precedent to, on a case-by-case basis, to people trying to secure their release from immigration detention. And as to the significance of the Love-Thoms precedent, a series of questions arise, and I'll try to sort of work through those in the presentation today. So the first one that I'll put to you is this case, Love-Thoms, the first to recognise Indigenous lawmaking authority in Australia? The second question is, what is the source of this Indigenous lawmaking authority, which is a critically important question for legal theory that the court simply cannot avoid anymore. The third question is, does this Indigenous lawmaking authority act as a limit on state sovereign power? And if it does, how can this new relationship contribute as a matter of law and fact to the reconstitution of the Australian polity in a way that's more just and more complete? And fourth, and this part is the speculative part of the project that I'm still sort of meandering my way through, what methods are there in settler law that can be deployed to keep this possibility of a renovated Australian polity open, to keep the door open? It's been opened a little bit. How do we keep it open when governments have shown already that they are hostile to its implications? And I want to say something in particular about methods that already exist in common law jurisdictions that enable a court to apply foreign law. And these are called principles of private international law or choice of law principles. And I want to ask us, are these a good fit for the circumstances at hand, the types of questions that are raised by efforts to apply the Love-Thoms precedent? But yes, and I may, if we have time, come back to our efforts at the Indigenous Law and Justice Hub to put an argument like this about the application of choice of law principles before the High Court in the Montgomery appeal. So there may be something that we could discuss about how to put this into practice as a practical matter. But coming back for a moment to the demography and history of the Kansas states, and glossing over a great many differences between those states, which are of critical importance in different contexts, it is true to say that their settler-colonial past and present bears many similarities right from the ground up. They're all former English colonies with similar settler-colonial histories of engagement or non-engagement with Indigenous populations. They all inherited the English common law, and they're all rich states. And in fact, the descriptor that I'm using, settler state, has come to mean, at least in my neck of the woods, to refer to the fact that in each of these states, colonising populations never went home. There was never a demographic decolonisation process. And so that Indigenous peoples were made effectively to be minorities on their own lands. And not just minorities, but as Indigenous scholar and public intellectual Noel Pearson has very astutely put, Indigenous minorities in Australia and elsewhere are extreme minorities. So in Australia, they make up just 3% of the national population. And what this means, it won't be lost on any of you, I'm sure, is that in the ordinary day-to-day democratic functioning of the state, Indigenous Australians are outnumbered by the rest of us by 35-1. Now, as to the legal backdrop, and I want to keep legal technicalities to a minimum so we can focus on the big ideas. And also to say that in this field there is no bright line between law and politics. Much of what we call settler-colonial law has been devised with a very specific and concrete purpose in mind, which is to justify colonisation and to support settler supremacy. But I think a bit on legal doctrine might help us to understand the significance of the Love-Thoms case and how it came about, and help us to think through those questions that I posed. So, in each of the four states in the Kansas sort of bloc or coalition, because they sometimes behave like one in international law, the assertion of sovereignty over the territory acquired by the British Crown was premised on an idea that has its origin in international law, that there was no pre-existing sovereign in those territories, and that's critically important for the legal theories that support settler constitutionalism. What that means is that the claim to sovereign power is based on settlement itself, not on treaties and not on conquest, so that it's a claim to original sovereignty, not a sovereignty that is a derivative of an original Indigenous sovereignty. And because there was no pre-existing sovereign, the logic goes there was also no law and no lawmaking authority, so that the legal, the baggage of the settlers, the English common law, flooded into that territory in its entirety, filled it up comprehensively as though there was a legal vacuum there prior. That's been the orthodoxy for a long time. And in Australia, some of you may know this doctrine came to be known as Terra Nullius, the doctrine that the land belonged to no one. However, it remained and remains the duty of judges to declare the content of that body of law that they brought with them that flooded into that territory. And in 1992, in a case named for the lead applicant Eddie Koiki Mabo, a Torres Strait Island man, the Australian High Court conceded that that body of common law could contain pre-sovereign property rights held by the Indigenous original inhabitants, because these could survive the acquisition of sovereignty and could continue with the protection of the common law until validly extinguished. And this case was transformative. It corrected what the court called a mistake of fact, the mistaken belief that Indigenous peoples had no property rights or no concept of property, and it conceded that Indigenous peoples were, at the point of colonisation, organised in accordance with what is called bodies of traditional law and custom, but it did not recognise that those pre-existing polities were sovereign, and it did not recognise that their law-making authority continued past the point that sovereignty was acquired. Instead, those parts of traditional law and custom that remained substantially uninterrupted since sovereignty was acquired, which in most parts of Australia was 1788, they're treated like a set of facts that can be used as evidence to provide the content of native title rights and interests. So to break that down, the common law does not recognise Indigenous law. It recognises rights and interests, the content of which is found in traditional law and custom as it existed in 1788. Okay, so the point of all that backdrop is to make this point that crucially, since Mabo was decided 30 years ago, the Australian courts have said over and over again, we can recognise property rights, but there cannot be a parallel law-making system in this territory. We are the sovereign, and the sovereign is it. Our power is uniform and consistent and comprehensive, and sovereignty itself is non-justiciable. We will not hear a claim in court that presents a claim that is adverse to the sovereignty of the Crown. So that's the backdrop, and it is very harsh and very strictly policed by settler courts. So very briefly, legal pluralism is a challenge to this sort of state centricism and the monism of law. And it's a very large and diverse field, but it's animated by a central concern, which is that the state's legal system is just one legal system among many, and that these coexist in the same social field and operate over the same territory. And normatively, legal pluralists share the normative aspirations of other pluralists, which is to push back against the supposed neutrality of the state and its insistence on being the sole source of law and its law being comprehensive. Now, it's connected in a very uneasy way with what I would call analytic legal philosophy or legal theory, because it typically eschews the question of whether there is a definition of law which is fit for all purposes, for all communities in every part of the world. And instead, it insists as a field on looking at subjective accounts of what law is, offered by the people who feel the obligation to adhere to those norms themselves. So insists on subjectivity and insists on a case study method. So it's not a pure theory of law, it is examining law-like patterns and normative systems in situ where they occur with local communities. And that is part of its legacy as a field that has its origins in legal anthropology, just to complete that statement. So, remembering my suggestion that the fulcrum of legal pluralism in Australia and I think also in the other settler states that I'm familiar with, the fulcrum is this legal distinction between Indigenous peoples on the one hand and settlers on the other on the question of status. So with that in mind, I'll embark on the core case study for this talk. So the Love-Thoms case gave legal pluralists in Australia and indeed elsewhere a lot to think about. A slim majority of 4 judges versus 3 in the minority recognised that it is the connection to country that Indigenous Australians have that means they can never be aliens to Australia, as that term is understood in the Australian Constitution. And that means, as I said, Australian Aboriginal people cannot be deported. And in the Love-Thoms case, Daniel Love and Brandon Thoms, who were born in Papua New Guinea and New Zealand respectively, who were citizens of those countries and not citizens of Australia, successfully challenged their detention and their proposed deportation on the idea that they are Aboriginal men. In other words, connection to country is a principle with legal consequences in settler law, and in this case it really does appear to condition sovereign power because it limits the sovereign power of the state to remove Aboriginal people from the continent and islands we now call Australia. But all four judges made it clear that in their decisions they were not recognising Indigenous sovereignty, and they were very careful not to suggest that they were challenging the sovereignty of the state. And for this reason, because the judgments do not contain any reference to a right of self-government, Indigenous sovereignty or self-determination, when I first read the judgment, I received it with disappointment, as did other people. This is back in February 2020, when the world as we knew it was still relatively intact, and I thought this is a judgment that confers a limited benefit on a small number of Aboriginal men and their families, but it leaves the sovereignty dogma intact and perhaps smuggles it further in and embeds it further down in legal theory. But I have changed my mind on that now. The sovereignty talk in the judgment is now not as necessarily, to my mind, as necessarily arbitrary and avaricious as it looked to me the first time I read that case, because it now seems to me that sovereignty is balanced in the case with a competing concept, which is the source of Indigenous traditional authority and lawmaking power, which is country. And that's what I'd like to reflect on today. And essentially, I have come to this new understanding of the import of the case by talking to my Indigenous colleagues a lot about it, people who have a greater experience and are much more proximate to this idea of country than I am or will ever be. And especially, I've spoken to my collaborator on a project which was part of the one that Ulf and Ludwig and I are working on, an Indigenous scholar, Mary Spiers Williams, who is based at the ANU. So I feel that I missed what is centrally important about the Love-Thoms decision, that it is a novel attempt by Australian settler judges to bring settler sovereignty and country together in a relationship as the two foundational sources of settler and Indigenous lawmaking authority. So that's my first contention. And my second is that through this device, this newly relational understanding of sovereignty, the Love-Thoms case offers us a glimpse of what a fully developed legal pluralism might look like in Australia and the other settler states. It shows us that it is possible, and I think that is a very progressive move. And given this importance of the case, it's even more significant that the Morrison government tried to have it overturned. I want to stress this is highly unusual for a Commonwealth government to come in and challenge a case that has been in existence for 2 years. It shows their sensitivity about being able to police membership of the Australian body politic. And perhaps that's understandable, but it is not understandable to go back to a High Court after it has made a decision about the content of constitutional law. That's not the kind of behaviour that we expect from our representative institutions. Okay, so let me begin then with an observation about the way that the four majority judges in Love-Thoms approached this idea of country and connection to country in their reasoning. So they all non-Indigenous judges, speak in various idioms about connection to country, but significantly they don't attempt to classify this connection in accordance with the taxonomies that we usually use in settler law to navigate the intersection of Indigenous traditional law and custom and settler law. So connection to country in the judgments is not a common law right. It's not a set of facts capable of yielding common law rights, and that's the native title prism. It's not traditional law and custom, although its meaning might be expressed in traditional law and custom. It's not a rule, it's not a right, it's not a norm, and it's not law, but it might be the source of and repository of, or a vehicle for, Indigenous law. And very critically, as I've said, it's not sovereignty. So accordingly, some of the significance of this judicial discussion, to my mind, is that connection to country, because of what it is, has escaped and evaded the categories that settler law historically uses. And I think this is striking. It is left out there on its own terms, undefined. And we might think about that as a very central, foundational expression of legal pluralism. And I feel that I need to say at the outset that I have no insider knowledge of what this idea of country means to Indigenous communities. My focus is, as it is in other things that I write about and think about, on the relationship, and especially about what country might require of settler officials and of settlers in general, and those of us who think and talk about law. And in particular, I feel that a major responsibility we have as settler lawyers and officials to country, as I am coming to understand it, is to resist the temptation to give into our cultural and legal obsession with discerning and finding finer and finer points of law in pursuit of more and more precision and more detail and more comprehensivity. And all of that legal endeavour is, of course, in the pursuit of analytic certainty. And so I would like to say I think this might be a virtue in many contexts, but it does not serve a relationship to country. It doesn't serve the relationship at all, and it doesn't help us to come to grips with traditional authority. And indeed, some Indigenous legal theorists have pointed this out. They have said Indigenous law is more concerned with the elaboration and promulgation of norms and principles and applying those to new fact situations than it is with divining rules and norms that govern behaviour. So I'm taking that on board, and I think perhaps the judges of the High Court have taken on board something similar. Now, it's always risky to refer to pop culture in a diverse audience, but I hope someone here at least has heard of Billy Bragg. Anybody? Yes. Yes, oh, that's fantastic, because last time I mentioned him in a public address, nobody knew who he was. Sorry? It might be an age question. Oh, yes, I know. Well, that's the other risk, isn't it? Just showing my vintage here. Anyway, Billy Bragg, some of you obviously know, is a folk and protest singer from the north of England who everybody I knew really loved a lot in the early 90s. And he sings about this in one of his most well-known songs, Must I Paint You a Picture? Beautiful. He says, we've got to resist the temptation to take the precious things we have apart to see how they work, because, he says, they never fit back together again. And I think about this with our cultural traditions as people from the West and what we can do to resist that temptation. And I don't think that it will surprise any of you that this propensity to pull things apart in pursuit of certainty is exactly what the Commonwealth government is doing to Aboriginal families when it purports to deport them back to deport people back to their countries of citizenship. And I do think it is easy to, in all of this intricacy and nuance, to lose sight of the idea that deporting long-term residents from Australia, including people who were born there, and as a New Zealander I have a special interest in those people, because many of them are New Zealanders, is a very dubious way to enforce criminal law, and it might be one of Australia's most notorious claims to fame internationally, and so much so that scholars that I know have now talk about working in the field of crimmigration. That's how ardent some of our past governments have been about using deportation as a tool in the criminal justice system. However, the fact that the country has retained its integrity in the High Court, viewed through the lens of the very top legal jurists in the country, is important and progressive, and I want to draw our attention back to that. Not because I think the judges have anything like a fully developed theoretical model of what country is, but because it looks like glimmers of light, a little gap where we can see what is underneath and actually attend to it on its own terms. And I think perhaps it shows us, and Billy Bragg would definitely agree, that the uncertainty of legal pluralism is tolerable, and it is uncertain, necessarily so, if on the settler side we can also be okay with not knowing everything all at once, not having access to everything for our forensic examination. So I'm just going to check the time, make sure that I'm on track. Yes. So although they described the connection to country in slightly different ways, the judges all referred to a very powerful passage from an older case from the Supreme Court of the Northern Territory in Australia, which many Australians know as the Gove land rights case, so the precursor to the doctrine of native title having a hold in Australia. And the name of the case is the Milipum and Nabalco, and the judge in that case, Justice Blackburn, had spent weeks on country with the Yirrkala clans, Gumatj clans and others of northeast Arnhem Land right at the top of Australia, hearing evidence about their legal system. And in the course of hearing that evidence, he said that the law of the Yirrkala clans showed that the fundamental truth about their relationship to the land is that there is an unquestioned scheme of things in which the spirit ancestors, the people of the clan, particular land, and everything that exists on it and in it are organic parts of one indissoluble whole. So this scheme of things, this indissoluble whole, I think, is by implication the High Court's idea of country. And the scheme of things was referred to judges as entailing a connection, quote, that is older and deeper than the Australian Constitution. A connection that revealed the deeper truth of the Mabo case, namely that, quote, connection to country was not severed or extinguished by European settlement, nor by the assertion of sovereignty, nor federation, and nor any event after federation. And in those circumstances, in the words of one judge, to classify a member of an Aboriginal society as an alien to the body politic would be to recognise that the Crown had power to tear the organic whole of that society asunder, when in fact recognition of this connection means that the sovereign power of this nation, this is a quote, does not extend to the exclusion of the Indigenous inhabitants from the Australian community. So at the same time as recognising connection to country, the judges, as I mentioned before, emphatic that none of this reasoning is to accept that Indigenous peoples have sovereignty. They have connection to country. And I want to suggest that this is a concept which has great utility given sovereignty dogma in Australia and elsewhere. So, as Mary says, we see country through a crack in the door. It's not fully visible or accessible to settlers, but it's there. And Mary has suggested to me, my co-author, that we're seeing it through cracks that are in a very brittle, superficial overlay of settler law and sovereignty. In her mind, those cracks are there, put there by country in the process of asserting itself, which it will always do. As she says, country will grow through and over settler law and all of our other human enterprises and conceits, because, as her co-teacher, Walpuri man Wanta Patrick said to me last month when I was with Mary, he said, humans didn't come up with the law came up with us. It's eternal and it's not subject to human alteration or change. So even having left the connection to country and country itself to stand out there on its own terms, referenced but not defined, the court still had to ask itself, who are the humans who by their connection to country are Aboriginal Australians? And they answered this question by reference to the so-called Tripartite Test from Mabo, that case I mentioned earlier. And this is the test that has now become the centre of this latest legal meeting between sovereignty and country. That test says, it has three parts, as you might expect: membership of the Indigenous people. And remember, this is the definition that defines an Aboriginal Australian and creates their membership in the Australian body politic, even without citizenship, just to recap. So membership of the Indigenous people depends on biological descent from the Indigenous people and on mutual recognition of a particular person's membership by that person and by the elders or other persons enjoying traditional authority. The question on everyone's mind, at least the people who work with the same set of ideas that I do, is recognition of a person's membership by traditional authority effectively the exercise of lawmaking authority? Is this the recognition of lawmaking authority for the first time.
Sorry,
And then,
Kirsty, could you repeat? There were quite a number. Could you repeat those requirements?
yes, sure. So first, membership depends on biological descent, self-identification in shorthand, and recognition by elders or other persons enjoying traditional authority. And this is important, right, because it appears that if traditional authority is the exercise of lawmaking power, then it is Indigenous law that determines membership in the Australian body politic. And the minority judges were absolutely appalled by this idea. In the words of the Chief Justice, who was in the minority, to suggest that traditional laws may be determinative of the legal status of a person in relation to the Australian polity is to attribute sovereignty to Aboriginal groups, contrary to Mabo number 2, impermissible attribution of sovereignty to Aboriginal groups. And so to break this, because the test is quite complexly arranged, the Commonwealth has argued that biological descent conditions traditional authority, so that only persons who are biological descendants in accordance with settler law can be recognised as members by elders. And Indigenous communities, as you might expect, have argued that traditional authority determines the meaning of biological descent, so that biological descent is a matter for the groups to define. And the difference between the two approaches became critically significant for Shane Montgomery, because Shane Montgomery was adopted into an Indigenous community. He does not have, or he does not know if he has, biological Aboriginal ancestors, but nonetheless he claims he is an Aboriginal Australian. And to think through this as an expression of legal pluralism, I would like to say just a bit about Shane Montgomery and what he said in his case, and what the elders said about his status. So Shane Montgomery is a New Zealand citizen, born in New Zealand, not an Australian citizen. He has Maori ancestry on his father's side through the Ngāpuhi group, but this is irrelevant actually to his status in the court, but it is something to note, the long history of inter-Indigenous engagement across the Tasman Sea. In the late 90s, as a 15-year-old, he entered Australia and was granted a visa, which is an indefinite visa, but not a tenure-track visa, so it doesn't lead to permanent residency and then citizenship. All New Zealanders get that visa automatically the first time they enter Australia. And then in the years after he arrived, he became homeless. He was placed in a shelter for Aboriginal men and was later taken in by a Malanjali family, eventually being initiated into the Malanjali community by participating in ceremonies that are designed to mark and celebrate a person's maturation as an adult. He had many encounters with the police, mainly with respect to property crimes, and in 2018 he was sentenced to a term of 14 months imprisonment. Any term of imprisonment over 12 months results in the mandatory revocation of your visa because you are thought automatically to have failed the character test on which the visa depends. So he was placed in immigration detention, and then the Commonwealth moved to deport him back to New Zealand. He was still in detention when the High Court made its determination in Love-Thoms. So, in his affidavits protesting his incarceration, seeking habeas corpus, a release from being detained, he said this, and I think it's important to hear it in his words. I identify as Aboriginal. I've been accepted as such by the Malanjali clan of the Yugambeh people of South Queensland. I was reared up within the Malanjali people and initiated at Bow Desert, our country. I am a Malanjali man. I do not need to have a biological ancestor to be Aboriginal, according to the traditional laws and customs of the Malanjali people. This is the decision of the elders in my family. I am an Aboriginal man, and this is my country. When he was pressed by immigration officials about his biological descent, they were trying to figure out if he was in this new category or not, he said he thought that his Maori ancestors had had a connection with an Aboriginal clan many, many years ago in the earliest days of colonisation, but he just didn't know if he was directly descended from an Aboriginal ancestor. One of the elders supporting his claim to be an Aboriginal Australian said this: Shane's bloodline is Malanjali. He was brought into this bloodline by being reared up by our family. He has taught our ways and he's one of us now. He belongs to country now. The judge decided on this basis it was reasonable to think that he might be Aboriginal Australian and ordered his release. And then the Commonwealth, outraged, appealed that decision to the High Court. We can see what they're worried about. They are worried about criminals finding a hospitable Aboriginal community to adopt them, having no control over that process, and opening the floodgates to a bunch of people being able to remain in Australia when they would prefer to have them sent back to their countries of origin. In the Commonwealth's appeal, they said, again, deferring to the membership decisions of an elder is akin to conceding sovereignty to those elders, which they said is impermissible. They said that the key criteria is biological descent, and in their words, that requires a genetic relationship with an Aboriginal person. And they also have a claim about uncertainty, which relates to the perceived difficulty of understanding the content of Indigenous membership law. They say if biological descent does not decide the matter, this objective standard, then settler officials would have to attend to traditional laws and customs governing adoption, which, quote, will vary between Aboriginal societies and possibly even within societies, so that the reach of the government's power, they say, could be ascertained only by matters specific to particular Aboriginal societies, and these matters are difficult to ascertain and they might vary over time. So these are the arguments that we faced when we thought about how are we going to secure the lawmaking capacity of the Murrumbidgee people without suggesting that all Indigenous communities would have a similar view on status. The biological descent as genetics argument, I think we all probably agree, suffers from problems of circularity and of science, but we can discuss those later on if anyone would like to. And of course it is ultimately a social idea, and we can expect that different societies will give it different meanings. So it's subsumed within this broader question about legal pluralism. Now, my third proposition for you all is that these arguments from the Commonwealth government, the descent, sovereignty and uncertainty arguments, can be resolved by deploying methodologies that the courts already use to apply foreign law, sometimes called choice of law rules. And this, I think, would require a categorical and desirable move away from the approach in Australia that looks at Indigenous law only as a set of historic facts, and instead approach Indigenous legal systems as living, generative sources of law where decisions about membership can be made in response to current circumstances and current political and environmental contexts. The fact is that in common law jurisdictions, and I confess I don't know what the civil law analogue is, so I'd be interested to know more about it. In common law jurisdictions, courts do regularly apply foreign law to determine questions of status, for example, to decide whether or not a person is a citizen of a foreign state, which is almost by definition a question that can't be answered except by reference to foreign law. And as some of you will know, in common law jurisdictions, questions about the content of foreign law are discussed by the court as matters of fact, and they're argued, for example, by expert witnesses, and if there is disagreement as to the applicable rule, the most probable interpretation can be decided in the ordinary course of judicial inquiry. So the potential of this approach for settler Indigenous legal pluralism is to be found in the acceptance that the application of foreign law in this way does not diminish the sovereignty of the host state. In fact, it's commonly expressed as a expression of that sovereignty, the sovereign having chosen to apply foreign law. And there is a vigorous conversation going on within legal pluralism about choice of law in different contexts, being ably advanced by scholars such as Paul Schiff-Berman, Ralph Michaels, Nicole Rowan and others. I'll just briefly say some of the hurdles that may have to be overcome as I understand them from what other people have written about this possibility. There are some optical hurdles, but to my mind they're not insurmountable. Some people, for example, think that it is paradoxical, perhaps improper, to categorise or approach Indigenous law as though it were foreign law. to my mind, this is not inaccurate, actually. Conceptually, there are multiple bodies of law that are foreign to one another, operating on the same territory. Others worry that this method could inveigle state-based ideas of law or concepts into judicial understandings of Indigenous law, and I think this is a more powerful argument, and it's been made particularly well by Nicole Rowan, who is an analytic legal philosopher who works on pluralist theories of authority. So I think generally the risk of inappropriate translation or mischaracterization is not insignificant. And of course, much depends on the willingness of judges to speak to the right people, to recognise authority of elders and others giving expert advice to the court. But I think the fact that the judges in the High Court were prepared to reference connection to country in terms that they understood it as the source of Indigenous law, and especially that they described it as a principle that's older and deeper than the Constitution and therefore of settler law, opens a possibility that this judicial methodology could engage a pluralism of legal theory, a pluralism about what law is, not orientated solely around the rather inhospitable all or nothing, winner takes all competition that inevitably results if we start with state sovereignty. So the great potential I see in references to country is that they enable Indigenous legal theories space to help reconstitute the relationship between Indigenous and settler legal systems. This is my concluding argument, although it is relatively lengthy, so I'm not quite done, but I think I still have time. Okay, I'll condense it then. I'll just say something about the transformative power of country, the idea, and then I will conclude. Country has not been, judicially at least, shoehorned or excluded from settler legal categories and taxonomies, and to my mind this means that it retains its transformative power. And connection to country in all of the scholarship and thinking I have read from Indigenous legal theorists carries with it a theory of relationships, that the source of authority is proper relationships. Christine Black, a Montgomery woman and legal philosopher, for example, has said that Indigenous law is above all a law of relationship. Mary Spiers Williams has written that responsibility to country entails all of us to engage in a relationship of relational autonomy. She says the unique responsibility of each person and our most fundamental relationship with country means we respect the autonomy of others. It's from this relationship that we derive our authority as First Peoples, collectively and individually. She says authority is the obligation to fulfill our role in the network of relations that constitutes our home. So, Indigenous concepts of authority are dependent on good relationships. They don't seek to occupy the entire field in the way that sovereignty does. And so I'll conclude by suggesting that traditional law and traditional authority expressed in traditional law and custom can supply terms of engagement that we don't have when we are talking about totalising settler sovereignty. And so to finish, I would just like to read a passage from a Palku legal philosopher, Amber Quire-Mullen, that is the type of analysis of belonging that we might hope can emerge through this new expression of legal pluralism. She says, and of course, I want to remind people that this type of belonging now, because of the decision in Love-Thoms, is also a type of belonging that is relevant to membership in the Australian body politic, not just in Aboriginal context. So she says, to be an Aboriginal citizen of an Aboriginal nation is to exist within a network of relationships, the pattern or story of which was laid out by the dreaming ancestors and is upheld through the law. To enter a nation not your own is to carry the network of your own country within you, but also to exist within another network. There may be connections between your own country and another through, for example, through intermarriage or song lines. If these connections cannot be determined, strangers are often assigned a place within the kinship system of the nation that they have entered, and this brings them into the fabric of relationships that comprise the nation and the right responsibility duality encompassed by those relationships. So this set of ideas is echoed in lots of writing by Indigenous legal theorists who comment on the pervasive importance of kinship as an organising principle in Indigenous law, connecting people and peoples to one another and to land and to all the other persons, human, non-human and superhuman, that constitute the communities that we live in. I'll just end there for now. Thank you.
Thank you very much. I'm sure there's going to be many questions. Let me remind you a little bit about the question and answer period. The first half hour will be recorded, and since we have people online and people here, for those people online, we use the chat function to run the question and answers. So you write in the chat to ask a question if you're online. And since we are a mix of researchers from different fields, please tell us your area of study so we can make a question from different disciplines. So write your name and area of study. And we also allow for follow-ups, and then here, if you're here in the audience, you can just put up a finger instead of a hand. And in the chat you can write follow-up to whatever person you're following up to. Very good. So, is there any questions? I think I see a list there. We start with Ludwig.
Now we have a mic. Thank you, Kirsty, for this really sort of interesting and provoking speech or talk, which makes you think about a lot of things at once, and it's a bit challenging also to raise questions here that sort of seem that are, I mean, relevant in a way. But I think I'm going to start with one question, and that is, I mean, the way you present legal pluralism as the basis for your approach here, and also as a sort of potential, as a theory which has a potential of sort of questioning the established notion of law in Australia, for instance, in relation to the laws and traditions of Aboriginal peoples, seems, I mean, I was wondering about that, because it seems like legal pluralism sort of denies that legal systems are necessarily only those systems of law, those bodies of law that are sovereign and comprehensive,
Yes.
and that are defined in traditional sort of legal positivistic ways of being built around sort of more or less formalized sets of primary norms and secondary norms and rule of recognition and so forth. So it seems to deny that.
Yes.
But on the other hand, your thesis seems to be that this case that you pointed out, this High Court case from 2020, is promising for legal pluralism. But it's promising only because it was recognized by the courts and by the legal system of Australia. So doesn't the judgment, rather than sort of questioning the unique and privileged status of Australian legal system, doesn't it just confirm that the Australian legal system is distinct, and that whatever is recognized as law must be recognized by the courts of the Australian legal system?
Yeah, it's a good point. It's not at all what I meant. So I'll answer it in two ways. So I think the fact that Indigenous law exists and governs the lives of Indigenous communities in places like Australia is it is realisable whether or not, regardless of what the state says about the force and authority of that law. So I think nobody would question the fact that there are bodies of law that govern Indigenous communities. The real question about recognition is whether or not the state will back up, enforce, or defer to those bodies of law. So the promise I see in Love-Thoms is an expression of deference. So it's not so much the newness, the novelty is not so much that there is such a thing as traditional law and custom. The newness is that seems to be an acknowledgement of its normative force and that the state is prepared perhaps to defer to pronouncements that come from people exercising traditional authority. And I'll also say that, that when I'm thinking about this, I have in mind a sort of stalemate that one could look at as a state of mutual non-recognition from Indigenous legal systems on the one hand and the settler state on the other, because there's plenty of settler law that Indigenous communities with their legal theory would consider to be either not law at all, or invalid, or lacking the requisite pedigree, or more importantly lacking the requisite relationship with country. So it would not be hard to see that in an Indigenous community these same questions about recognition and source play out differently, but with respect to settler law, that it is illegitimate or that it is invalid because the relationship to country is not being honoured.
Could I ask you a follow-up on your question?
Yeah.
I have this. I don't know. Yes. So because I wonder a little bit. Are you and other people arguing for that Indigenous law is sufficient for determining Aboriginality, but are you also arguing that it's necessary? So, or could the common law can also, is it sufficient that the common law also recognize somebody
Yes.
as Aboriginal?
Yes, that's right. So this definition that I spoke about is not the only one in circulation. So it is true that the Australian governments have for many years defined Aboriginal people entirely on their own terms, like very sort of egregiously unjust systems of classification. This definition refers to traditional authority, and that is the key. So it is not
it's necessary. So
necessary. Yes.
The argument is that that should override. So if the common law wants to recognize somebody, that can be overridden by the Indigenous law.
Yes.
Okay, so it's a strong position. In
that is what I take to be the central importance of traditional authority.
But one could have the view that, let's say that somebody is not recognized by the Indigenous law for some reason we think is violating some norms that we care about. For example, you're homosexual and therefore you're not recognized by the elders. You could think that should be possible to appeal that to outside the Indigenous law, maybe the common law. So you can have a more softer view saying that both the common law and the Indigenous law are sufficient for becoming Aboriginal. But that's no one arguing that.
I don't think that the state possesses traditional authority, so it would not be able to recognise the membership of a person in a community by providing the requisite mutual recognition.
In your view, how should we solve this problem? That
they're not Indigenous.
Okay, so if you're homosexual, let's say that you're excluded.
Yeah, I mean that's an extreme example. Yes, I mean this is a jurisdictional problem, and there are plenty of jurisdictional problems operating in all countries in the world. So it would be a question about what the constitution that allocates authority to make decisions about which territory and which
in Canada,
people.
For example, they override a lot of Indigenous laws.
I don't think that's true. Yeah, I mean, I think if you have a treaty, for example, in British Columbia, it is entirely, the agreement is that the law of the First Nation prevails in those circumstances where its jurisdiction is protected. So I don't think this is a problem that is just...
That? So you think it's okay that you can have certain areas that violate human rights inside...
I think that it's a problem that's not about Indigenous people. I think this is a problem about the allocation of authority in a complex, plural, perhaps federal system.
There's something I'm misunderstanding here. I mean, why is not a problem?
Well, I mean...
It doesn't matter, it can be Aboriginal law, it can be other law, but if they violate certain normative standards like human rights...
Right, so your proposition is that any type of legal pluralism that is not subsumed within an overarching reference to human rights would be unjust. Yeah,
I mean, I think that was
legal pluralists, I think, would disagree with that.
But I don't want to hijack your question.
No, I think you. I think actually you're raising a different question. I mean, yes, and I wasn't really into the sort of the normative sort of justification for this. I mean, I see your question as well. You could ask that, but I was more into to provoke to ask. I mean, to put it this way: when you say that according to this decision,
yes,
it is actually the Indigenous law that determines membership.
Yes.
But was it? It was the court. It was the High Court that decided that the criteria for membership should be found in these bodies of Indigenous law. So it was actually the Australian legal system that decided.
Yes, so maybe the innovation of the High Court is to create a jurisdictional relationship here and say, in these matters that involve the membership of a person in an Aboriginal community, that is your decision, and we will not displace it.
Yeah, but it's their decision only because the High Court so decided.
Yes, so the High Court has acknowledged the relationship.
Yeah.
Yes, you're right.
So
You're
in that
absolutely
sense,
right.
it's sort of subsumed under the authority of the Australian legal system.
I'm not sure that follows. I'm really not.
Because they could have decided otherwise.
Yes,
And
they could have.
reverse that
Yes,
decision.
but Indigenous law and authority would remain intact. There's nothing that is the source of Indigenous authority is
the
not
source
sovereignty.
would remain, but the authority of that within.
But the practical expression of it would be,
Yeah.
yes, suppressed.
Yeah.
But that's just the history of sovereignty in the settler states.
Yeah.
That's what it's always done.
Mm.
It doesn't create that authority.
No.
It can't. It's inherent.
Yeah.
But it has lifted itself back enough just to let it shine through.
But it's a matter of the authority, sort of.
Yes.
So that authority prevails within the Australian legal system in a way.
It would be, okay, so I guess, yes, the sovereign acting within its sphere of power could always revoke that little glimmer of light and say, actually, no, we've changed our mind. And exactly that is what the Commonwealth government wanted to happen. But it doesn't change the existence of Indigenous law and authority from their perspective.
Exactly.
It just simply keeps it in the realm of incommensurability. And so the relationship is what has been brought to light by the High Court, but the sovereign has not created that authority. It's simply allowing it to have consequences in settler law. So yes, on one hand it is very modest.
Kitty?
Hi.
Thank you. Yeah.
No worries.
I don't know if it is on. Yeah, as an Australian, this was very interesting because I did read about this event in the news quite a lot, but I didn't really understand the significance of Indigenous people not being treated as aliens.
Yes.
But anyway, I just also wanted to riff on Ludwig's question a little bit. So it may be that this part that you were talking about, keeping an uncertainty about the foreign law, sort of the Billy Bragg, not trying to analyse it too much. That might be a way to understand how it's not entirely subsumed by the sovereign law. I mean, by contrast, you might think if we tried to write into our law sort of the precise procedures that elders used and also the precise ways in which elders were selected, and how they made their decisions and so on, if we tried to sort of include that into our sovereign law, then that would look like we were just kind of subsuming this Indigenous law into our law. Like, okay, they have some good ideas about how to determine Aboriginal heritage, and we're just going to take that bit of law and write it into our law.
Yeah, incorporate it. Exactly. Yeah.
But if there's allowed to remain this kind of uncertainty, as you were talking about, then that does look like real deferral.
Yes.
Do you think
that's the foreign law example, I think?
Yeah, because it's like we're not quite sure how you're doing this, but you go and decide. Off you go and decide it. Is that
yes, as you have done for 60,000 years,
Yeah.
And I want to say that this sort of practice of plurality and deference is very well built into the way that Indigenous groups interact with one another as well. So a lot of these discussions about being in proper relationship with country and with other peoples speak to a sort of international order, for want of a better phrase, that has also been intact across the continent. So it's not, there's nothing novel about these questions of belonging and status. They might be differently argued, and we can see that in Shane Montgomery's case, where the bloodline is a legal concept for the Maranjali people. They have brought him into it and his genetics are irrelevant. There's two very different concepts of belonging. So I think methodologically there's no hurdle. Yes, it's a very different type of law, But I think that uncertainty and that indeterminacy and the necessity of entering into a relationship where the rules of engagement are settled, but that you don't account for every possible eventuality along the way, that's actually what's required in legally plural societies. And treaties are one way to secure this.
Mm-hmm.
Treaties don't set out every possible instantiation. They are jurisdictional arrangements. They say, you decide when the subject matter is this and the people involved are this, and we'll decide in this matter. So I think it can be done. I feel optimistic. I'll just add one other thing, because you've prompted me to remember this. Ironically, because Australia has had very few political mechanisms for regulating the relationship between First Nations and settler governments, no treaties, there's no Aboriginal rights in the Constitution, there's no doctrine of fiduciary duty, that all of these relational mechanisms are missing. It actually enables a more sort of a more fine dovetailing of law actually to be discussed and disputed at the level of the judiciary, which doesn't really happen in other countries. So this is an opportunity for a more effective and grounded legal pluralism, I think. Because there are no treaties, it has to be dealt with by legal people, legal officials from the settler and Indigenous side.
If I may, so you said that you changed your mind.
Yes.
And you came to see these latest court cases as really promising for legal pluralism.
Yes.
And I guess that is because you saw like real deferral, the possibility for sort of real deferral.
Yes.
On certain legal matters. And so is the hope that like this scope for deferral will expand a lot to incorporate other aspects of criminal justice, for instance?
Oh, yes. Okay. So, looking at the anatomy of the case, so we now have a concept of country that is a limit on sovereign power to exclude people, which is a constitutional power. So I suppose one way of answering your question is to say, well, what else can it serve as a limit on? Nobody is really willing to go down that track because it's strategically unwise to raise this possibility in legal forums, but it still remains a possibility. What else is connection to country constitutive of, like foundationally constitutive of a status that is not controlled by the Constitution? So that's one possibility. I suppose for the time being it is limited to membership questions, but I think where your comment might have some sort of traction that you may find interesting is that for the time being it's just traditional groups that have this authority. And some people are suggesting, well, because of the effects of colonisation and dispossession and removing children from their families, all this sort of statecraft of settler colonialism, non-traditional groups should also be entitled to exercise this type of authority to decide membership in a way that makes that person an Aboriginal Australian and therefore not deportable. So that is starting to percolate through the lower courts. There are people who are members of communities that have had their continuous connection to country interrupted, but who still might be able to make a claim that they are Aboriginal Australian. Yes.
Okay, I think Ulf.
Thank you, Kirsty. Very, very interesting, and I'm trying to translate it into, for instance, a Swedish context. What are you saying? I'm really not clear what that would mean. I hope we can discuss it further on Monday. But I have a question on what this could potentially mean for sovereignty in some terms. I'm not really sure. Could you see it as a kind of development towards some kind of shared sovereignty? Or would you say that there are, as it exists today, some kind of parallel sovereignty, but the sovereignty of the indigenous peoples are not recognized? today. So could you see some kind of parallel sovereignty, some kind of system of parallel sovereignty? Or could you, I mean, as I see it, and probably that's the quite pessimistic view on the development after this case, is that yes, you transfer some kind of powers within the system. I think it's a question like Ludwig's question, basically. I mean, nothing actually happens in terms of sovereignty, in terms of recognition of the indigenous peoples and their legal systems, because it's going to be transformed within the system. And on certain policies, they have a say, and on others, they have not.
Yeah.
So how could this challenge more of I think the constitutional order, as we were talking about the other day, the incomplete constitutional order? How could that challenge that?
Yeah, I understand what you're saying. So it is within the sovereign power of all sovereigns to decline to exercise their sovereignty over some matters, to leave that outside their jurisdiction. So I suppose there are forms of recognition that are not about sharing or conferring, but more about retracting, to let that inherency come through. And I'm sort of cheered by that idea, because I believe, again, to go back to treaties, this case will prompt political developments in Australia because of its import, and because negotiated agreements do provide a degree of certainty. So treaties in other places are agnostic on the source of Indigenous lawmaking authority, and I think that's very helpful. And you might even think of them as incompletely theorised agreements. So they will designate Indigenous jurisdiction by reference to a right of self-government, but they leave open the question of whether that is delegated or inherent power. So I think, again, when we're thinking about certainty, we don't need to necessarily lock everything down from the outset. What would be ideal is if this new ethos, that there is a deeper, more important source of authority, might encourage settler officials to be more circumspect about the reach of their power in matters, certainly that include Indigenous people on Indigenous land. Okay, this would seem like a modest concession if it were not for the very insistent denial of such a possibility that has really dogged settler common law in all four countries. The US is slightly different. So I do think of that process as a reconstitution of the state, not necessarily of sovereignty, since that's in the domain of settlers. Does that make sense to you? You can ask a follow-up, obviously. Oh, I'm not chairing, but if Gustav says it's okay.
Yes. So, but basically what you're saying is that we have a challenge of the constitutional order, but not of the state sovereignty. That is basically. So hopefully the constitutional order would include the people that were excluded from the very beginning. So that's the way to transform the constitutional
yes.
order. Okay.
Treaty constitutionalism does that, but Australia is also having a more precise conversation about how to change the constitution in order to recognise an Indigenous voice to Parliament. So that's ongoing. That will require a referendum and a majority of people in each state and a majority of people overall. So again, we come back to this question that you and I have spoken about before. How does a minority assert its very legitimate interests in the face of that them being vastly outnumbered? So I tend to think that the three branches of government are all responsible for the relationship. They know they are. They pursue sort of attention to that relationship in different ways. So we have a constitutional dialogue about national recognition. We have treaties which are at the state level, because that's where the authority has always been. And then we have the High Court sort of trying to to navigate a path through, and possibly hoping to nudge the political branches towards a negotiated settlement, so that it does not have to carry the burden of working through these jurisdictional questions in the face of hostility from the executive branch. I think of all of that together is definitely a renovation of the constitutional order that could be very profound.
Then Tim.
Yeah. Okay. Thanks.
Yes.
All right. I'll use this mic. So you said prior to this Love-Thoms case, the common law could recognize the interests of Aboriginal peoples and certain rights as well, but not the authority of a parallel lawmaking system.
Yes.
So I guess my question is, do you think that whether this case opens the door to, legal pluralism depends on the particular way in which the authority of, traditional authority of Aboriginal peoples is taken into account? So for example, if it turns out that the common law is taking this into account in order to take into account the certain interests that Aboriginal peoples have, then this might just not be such a new case. This might be just an instance of recognizing certain rights. I think maybe a good case to bring these apart would be one in which the traditional authorities of, say, some tribe declared something that was sort of clearly against the interests of, let's say, everyone involved, and the common law said we'll defer to that authority anyway.
I mean, these questions of.
I don't know if we have a case like that.
I mean, I think it's a tendency of those of us who operate in the sort of Anglo-American style of sovereignty to always look for the source of sovereignty, to always look for the conflict which will decide which one takes precedence over the other. And I think one of the benefits of legal pluralism is that it's much more focused on what happens in the day-to-day. I mean, there will be conflicts, obviously. Not all of them will be catastrophically destructive of the relationship. And it might be that it's in the interests of this balance, to use an example from Indigenous legal theory, that everybody does everything in their power to avoid this the necessity of playing a trump card in the event of conflict. So to go back to your question about rights and interests, it is peculiar because what I hoped everybody was talking about this case as being Mabo number 3. So there were 2 important Mabo cases. We all thought this will be the common law moving the integer from property towards sovereignty. And all of us were hoping for a right of self-government, and that didn't happen. Right? There wasn't the articulation of a right. So that's part of the indeterminacy of the case, is that it doesn't define any new rights or interests. It simply defers to traditional authority. Mm-hmm. So that translation hasn't happened. And in that way, it's not a continuation of the property discourse. It's something novel. I have the sense that there's more in your question than that.
My question was just, do you think that whether the common law recognizes the authority of an Indigenous people, merely instrumentally as a kind of a means to recognizing something else? Of their interests or rights, or whether they recognize it as fundamental. Does that make a difference to your, how optimistic you should be about whether we have opened the door to, what you consider legal pluralism? But
yes, I think I see what you mean. Yeah. So obviously the parties to the relationship have different normative political goals, and so I suppose the question is there something about this one which makes it more benign than other possible exercises of traditional authority? Well, I think so, because it is about status. I mean, it would be very difficult for settler law to define membership in a way that would make sense to Indigenous communities, and that is a problem that settler governments have struggled with in all of those countries. I mean, it seems to me a clear example of where settler law just lacks jurisdiction. You can't force people to be members of a group together. There needs to be something that's fundamentally organic. And I think that in part this case arose because everybody sort of at a baseline recognises that. It's a point of commonality. Freedom of association, for example.
More time for questions, if anyone? If not, I think you join me, and thanks, Vic, for this.
Oh, thank you, and
interesting
thanks
talk.
again for listening and for your great questions.
And I should mention that we have some talks coming up. We go on with a kind of Australian theme. We have Katie Steele next time. Neutrality about creating good lives. New panacea? Is that what you say? For long-termists. That sounds interesting, like something I should learn about. And then there's Stephen Gardner. I don't know what he's going to talk about, but probably something else. And then we go back to Australia. We have Bob Goodin, Structural Injustice in Mechanism and How to Disrupt Them. Thank you very much and welcome.
Thanks, everyone.